presentation, let me introduce our next speaker. It's Michał Pękała from DLA Piper, and we will focus on legal issues in gaming industry. Welcome.
Thanks a lot. Hi, my name is Michał Pękała. I'm with DLA Piper, an office and a law firm from Warsaw, and I'm mostly dealing with all kinds of video game development in terms of legal stuff, like intellectual property, funding, corporate stuff, also tax, all spectrum of issues. And the topic of today's presentation is I picked up a few legal aspects to walk you guys through it. Oh, it's not going to be very detailed analysis because we only have 40 minutes. I would like to point out a few important things that, in my opinion, are very important for you. And on many occasions, I noticed that these things are easily mistaken or avoided by video game developers, not only in Poland but in general. So if I would be asked to point out one thing that you have to pay special attention while making any video game, is the license. And the license is probably the most important thing that you have to ever consider while starting your new project. And why the license is so important? Because any video game is almost 100% of IP. Every piece of code you program for the game, any piece of engine that you structure, any graphic, any avatar, music used in any game, it's all IP protected, either under Polish law or US or UK. So to be able to, I really like this example, this citation, that as houses are made from wood and stone, games are almost exclusively made out of IP. And this is very true. It's not my citation, but it's very accurate. So in terms of how broad the IP is, in terms of any video game, it's not an exhaustive chart. It's just an example of how many IP rights are in every single video game that are created, that are presented here at Digital Dragons. So for instance, let's say patent. It may not be very accurate in terms of the Polish soil, but in US, games are patentable. The Polish video game developer Techland was able to secure the patent for Dying Light, for the mechanism which is behind the parkour of the main character in the game. So the way the main character walks onto the buildings and jumps on the roofs, it's patented in US, and the protection also falls in Poland. So if anybody would like to use the same technique as was used by Techland in their game, they would need a consent, probably the license from Techland itself. But the copyright is it's not the coincidence that the copyright is in the first bracket, because copyright is everywhere in video games. Like I already said, music, code, story, characters, art, even box design of your game, although not that often these days, because most of new game developers go digital, but even the box design is copyright protected. Trade secrets are the most elusive type of IP rights because they're not as coded as other branches, but pricing info, for instance, may fall under the protection. So when you engage, for example, a publisher, and you get into, you receive some knowledge from them about how they structure pricing for the game, you may be required to keep that knowledge to yourself. And it also goes both ways. If you have, for example, detailed knowledge about how you operate your own team in terms of how you lead the project of the game, it may fall under the trade secret. And it's always good to sign an agreement which is called NDA, which obligates both parties to keep all information that was received during any negotiation period or even small meetings to themselves, under the penalty on usually huge fines in money. Okay, and like I said, for instance, the example of IP right may be the BMW model used in GTA 4. For Rockstar to use this car, they needed the license from BMW. They couldn't just took the car because they liked it. They needed a license. Another example is the newest game of Injustice 2. The character of Batman is also copyright protected under US law, so they needed a consent from DC Comics to use the character of the Batman, and also they need another consent to portray the Batman in this exact way. Because this Batman is a little bit different from the comics. It's called derivative works under copyrights. So they needed two rights to use this Batman, to put Batman character into the game. One for the character themselves, and two to make derivative work out of the character. Another example is the whole Lord of the Rings universe. If you wanna make any game in Lord of the Rings universe, you need the consent, probably the license. But there is a tricky question: from whom? Because you can see the poster over there, and this is the poster from the movie, but not from the book. So there is always a tricky question if any IP was ever filmed and made out of the book, or anything else, out of the painting, a short story, or anything else. In terms of this particular example, you would need to go to right holders of the movie. And also, Gwen Stefani's avatar used in Guitar Hero. They needed a consent from No Doubt, and I would say probably not from Gwen Stefani's herself, because she probably gave away her right to use her own image in the video games to the publisher. At that point, I'm not sure who was her publisher at that time, but it tells you that even though you know the singer, for instance, Gwen Stefani, it may not necessarily be the person who would need to go for the license. But then again, it's under US law example. We don't have that many Polish examples here yet, so we need to rely on overseas examples. Okay, so already mentioned the Lord of the Rings story, so I made a small case study. So let's say you want to do the game in Lord of the Rings universe, and the game itself supposed to be placed during the siege of Minas Tirith. But then you should ask yourself, who should you go to ask for the license? And the bottom line answer to that question would be, would you like to rely on the siege of the Minas Tirith that was portrayed in the book, or that was shown in the movie? If you want to rely on the Minas Tirith that was in the movie, you would have to go to the right holder of the movie, either Peter Jackson or New Line Cinema. I'm not sure. The test how to get knowledge who holds the IP, it's called to establish the chain of title, and it's sometimes it's very hard work to do. It may not be that hard. If you want to do anything related to Star Wars, you know who holds the rights right now. But if you want to make your game out of, for example, a photograph from 50 years old, which is a very cool photograph, you may not know the author, but you still need the consent. Maybe not from him, because he's probably dead, but from his descendants. Why? Because in terms of copyright protection gives the right to allow everybody to, or not allow, to use their IP for the life of the author plus 70 years. So in terms of that photograph, it would probably still be protected. But in terms of Lord of the Rings, if it's the book, it's probably the rights are probably still with the family of Tolkien's. They're gonna expire in some few years, but they're still there. So always consider that. Never assume that it's self-explanatory where the IP for your subject of the game is. Always think hard and do the research before you decide to pursue that IP. Yeah, and a few points to take out from this section is that you cannot use any IP of third parties without the consent. Well, of course, technically you can, but you probably get sued for big money. And always establish the chain of title. Why is it that important? Because let's say you find a guy who says, okay, so I hold the right to Lord of the Rings, and I give it away for $1,000. You make an agreement, everything's fine, you start making your game. But then after 2 years, when the game is success, the real owner of the IP comes to you and says, well, I'm the owner, not the guy who engaged into the agreement. And it doesn't matter if it was a good faith on your side. It doesn't care in terms of infringement of copyrights. You still infringe the IP rights of the true owner. And establishing chain of title may be hard. It's very often easy, and you only need to use Google to do that. But at some point, you may face the situation when you would need some more deep background check for that. Oh yeah, and I'm very often asked whether game developers can rely on the so-called fair use, or in Poland, the permissible use under the copyright exception. In terms of video games, in 99 cases out of 100, you cannot. The first example under the Polish law goes to reporting, for example, citation, the private fair use, when you do something for your own. So as long as you create a video game, in your own bedroom, and nobody ever sees this, you will never have intention to monetize that game, you are probably safe and sound. But if you ever consider to make even 1 zloty out of the game, you need a license. You need a license, and it's not debatable. For some reason, there are different opinions. Well, not opinions among lawyers, but it's well-established consensus among a lot of game developers that, okay, I just said that I cited the true author of the IP, so I can use it in my game. Well, you cannot without the license, or of course the transfer of rights. But if it comes to the big IP like Lord of the Rings or Star Wars, nobody will give you the ownership of the copyrights. All you can rely on and is the license. Yeah, and contract with the publisher. The second most important thing when you engage a bigger studio or a publisher and you ask for money and publishing of your game. The publishing agreement is the most important document you will ever sign with the publisher. And it goes both ways. It sets rights and obligations of both you and the publisher. It's often that you agree to something to get money, to get promotion, to get marketing, to get support on Steam, on any other digital platform, but then you don't read the whole agreement, and there is nothing in it about what you just agreed over the table. So just remember that it doesn't matter what you agree in spoken with the publisher. If it's not in the agreement, they didn't agree to that in terms of the law. Yeah, and these are only the few elements of every publishing agreement. I'm not going to go through all of them, it's impossible, but let's just say the ownership of the game, the very first square. The publishing agreement should explicitly say that who's going to be the owner of the game when the game is created. And it's not just that obvious. You may think that, okay, so I'm creating the game, so I'm the owner. But the publishing agreement may very well say that, okay, we'll give you money, but you transfer the whole copyrights to the game to us at the moment of the creation of the game. So at that point, you're not the owner of the game anymore. You just get paid like any other employee in that respect. That's very important. Another aspect, for example, delivery. The publishing agreement should explicitly say what are the terms of the delivery of the game. Would you agree on milestones? How many milestones? Or maybe the agreement just say that, okay, I give you $2 million and you have 3 years to make the game. After 3 years, I will come to you and check how it goes. It's fine, but it's almost never happened. The publisher wants to have some degree of control over the creation of the game. So I would expect that they would set up the milestones for pre-alpha version, alpha, beta, and so on, so on. I would like to grill you guys for how the game is created, and they may, in terms of financial, for example, they may tie up the delivery with the installments of money that they will give you to create the game. So let's say I agree to give you $2 million to create a game, but if within the first 6 months you won't be able to show me the first version of the engine, I won't give you the rest of the money, and I will just back off from the agreement and you'll get nothing. So yeah, and there are so many other aspects that you always need to pay attention. I picked up a few which are very important. The rights granted I already mentioned. You need to know who's going to be the real owner of the game. The territory is very important as well, because under copyright law you may agree to give away your rights, for example, only in Europe, but not necessarily for the entire world. I know that you probably have seen a couple of US written publishing agreements, and if you read them, it says that the publisher will hold the copyrights within the whole universe. It's very funny. We don't do that under Polish law, and I will also say in a minute why I keep mentioning Polish law, while developers and publishers, they always insisting on keeping the agreement under US or UK law, depending on where the publisher is based. But yeah, we cannot agree, well, effectively to give away the rights in the whole universe. It doesn't work like that. But still, the territory is very important. If you want to monetize your game in Europe, for example, well, if it's a mobile game, for example, and you know that the biggest market for mobile games is probably in Asia these days, so why not limit the rights that you are giving to the publisher to Asia only? Why give away your rights to monetize the game in Africa? Africa may not be very tempting right now, but in 5 or 10 years, the market may change. You never know that. So if the publisher insists on expanding the territory, ask for more money. Of course, I know the bargaining position between young developers and publishers is never equal, but still it's worth to remember that you may always at least try to limit the territory, even if it's not successful. Reps and warranties, yeah, nobody reads that except lawyers. It's usually this section of agreement it's only with capital letters. It says that I represent and warrant that I have all the copyrights to the game and blah, 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 and blah, blah, blah. It's a form of insurance for the publisher, but if you structure the agreement correctly, also for the developer, because in the same agreement, in the same reps and warranties, you may ask developer to represent and warrant that under any circumstances, even beyond his control, he will give you the first installment of money within the first 2 weeks after the signature of the agreement. And if he won't, well, he'll be in breach of the agreement. It's always good to remember that. Yeah, the financials tied up with the delivery. You need to pay attention to what kind of financing model you agreed to, if it's going to be one-time payment or milestones, or you're going to be paid after you create the game, preferably not. Oh yeah, and the governing law and jurisdiction. Do not ever agree to the separation of these two terms. If the agreement is under the US law, go for the US jurisdiction of the US courts. Because it may happen that you have an agreement which is under the US law or UK law, but for some reason it's under the jurisdiction of French courts. So if it's ever a dispute between you and the publisher and you go to the court, you will go to the French court, and the very poor French judge would have to study the US law and then give away the verdict. And it may not be the best verdict because he's probably not that very well equipped with law in US law. Yeah, it's never worked backwards. Okay, so this is the example of one of the clauses from the agreement, and it basically says that the parties agree to make the best efforts to create the game under this agreement. And this clause seems fine, except that the parties, who are the parties? You and the publisher or your friend from on the other side of the street, we don't know that. And what's the game? It's just any game? So you just, the parties agree to make the best efforts to create the board game? I don't know. It just says the game. And this agreement, which agreement? You may have a few agreements. And so to do that, always remember to define the most important terms that are used in the agreement. In these terms, the parties would probably, the parties which mean that developer, which means that it's you, and the publisher, which is this huge AAA publisher company. The game, you need to define what the game is, the game you're creating. And then for the rest of the agreement, you just use the defined term, the game, and it says what is defined in the very beginning of the agreement. And this agreement is this agreement. This is what the entire document that are signed on the top, on the bottom, it says this agreement. Another example, the developer, which is already defined, it's you, undertakes to create the game on the platform. And then again, we didn't define the game, but there is even bigger problem. The platform. What platform? Is it going to be PC, Mac, PC4, Xbox One, Android? We need to define that, because if you agree to create a game on the platform and you created the game on PS4, the publisher may ask you, okay, but where's the version for Xbox as well? But I never agreed to the Xbox. Yeah, but it doesn't say that in the agreement. So do the same work without any additional money for the game to be playable on Xbox. So you need to double your efforts to do that, but the same money. Yeah, so be specific. Yeah, and remember this few takeaways that I know it may. I don't want to offend you guys, but it happens so often that people who sign the agreement, they don't read it, and it's very important to read the agreements, and the attachments to the agreements are as important as the agreement itself. It has to be considered as whole. It's not just the agreement, but if you have milestones put into the attachment or anything else, it constitutes the same document as the agreement. And never believe that when somebody tells you that this is not important, just leave it be. It's a minor thing. We just have to put it in the agreement because our lawyer told that. If something is in the agreement, it's important and it serves its purpose, always. Otherwise, it would not be in the agreement. So if you have any doubts, if you don't understand the working, always ask the publisher, the other party in the first place, to explain you guys what does mean. And well, if it's not enough, you may ask for professional help. It's never bad. Yeah, and it happened to one of the firm that they actually signed the agreement with the publisher, and they gave over the rights to the game under the same agreement. And they only found out about it when they, after 3 years, they were considering making sequel. But the sequel was already under the production of the publisher, and yeah, they learned it hard way. Trademarks. Trademarks are the second most important IP after copyrights. For a couple of reasons. For the reason of your own trademark, it's very often that the trademark, not the game, not the quality of the game, sells the product. I'm sure that each one of us knows at least a few titles that were sold only because of the good IP, good trademark behind it. Unfortunately, I can't name them, but we can discuss that afterwards. One of the game happened in New York, for example. Yeah. But the other thing to why trademarks are important, because you need a license to use the trademark of other parties to include them in the game. For instance, if you play GTA 5 and you go across Los Angeles, Los Santos, I believe. So if you see any billboard holding Coca-Cola or Pepsi brand on it, it's not just they Rockstar put it in the game. They have an agreement with Coca-Cola and Pepsi. You always need a license to use trademarks of others. It's a friend of mine who was creating a very nice piece of mobile game a few years ago. The game was about some sort of, well, the project is killed already, so I can talk about it. Hooligans from different teams were organized themselves under the, you were picking up the colors of a football club, and you were creating your own gang. Then you were going a little bit like in Pokemon Go. You were actually going to the place and using geolocation, you could you couldn't claim that territory for themselves. But the problem was that he was using the real logos of clubs. So when the game was almost done, he received a very nice letter from UEFA saying that, okay, you just infringed almost 300 trademarks of ours. And you can do that if you pay, I'm not sure the amount, it was something about 400,000 pounds at that time. So yeah, he decided not to pursue his game anymore. Yeah, and he put almost 4 years of work of him and his friends into the project, and yeah, it went as far as to beta version. Yeah. And this is the I hope there is no representative of Microsoft in the room, but there is. It's a very well-known case from early 2000 that when Microsoft decided to make their own MMO game, and they called it Mythica. They put, I think, around $30 million into the production of the game. But in 2003, they received the letter, well, not the letter, the lawsuit from Mythic Entertainment for obvious trademark infringement. And imagine what? Microsoft was creating the game called Mythica, but they never ran a public search on trademarks, and they didn't realize there is Mythic Entertainment, which is a video game company, also a creator of the game Camelot, which was also an MMO game. So Microsoft never went to the court. They realized that they would probably won't be able to win the case, so they settled. But the implications of the settlement was that the project was cancelled, so they just lost more than $30 million. They got very bad PR for that. But even worse, under the settlement agreement, they agreed to assign all the rights to registration, the trademark Mythica, to Mythic Entertainment for free, including any domain names for future. So they just spend a lot of money for a very stupid reason. And if they decided to run a very simple trademark search that would took, I don't know, 5 hours, they would know that this name is probably taken already, and there might be a problem if they want to pursue with this trademark. And all they needed to do was just go with a different name at that time. But they didn't do that, and they learned it, then again, a very hard way. Yeah, personal data. Why is it, I'm just gonna go very quick through that because I only have 40 minutes, I thought I have a little more. So why is this, I have 10 minutes, okay, cool. So why is it important? Because almost every game right now, in one way or another, process personal data, even if you don't realize it right now. If you use any type of geolocation, you process personal data. It may not be Jan Kowalski or John Brown, that type of personal data, but if you use geolocation, you use IP. You use GPS coordinates to localize the phone, and every phone is somehow connectable to the real person that holds it in the hand, so that's personal data. Moreover, big data. Big data, more and more games rely on processing big data, and big data allows for profiling, for example, which is another example. Yeah, so big data and data profiling connects each other. By processing huge volumes of data, you are able to point out, for example, the behavior of a particular person. What's my favorite color? What's the name of my cat? Where do you want, would I like to go for drinks or to restaurant? It's all in big data. If you have good algorithms, you can do that, but you cannot do that without the consent or other basis for data processing. This is very important because the idea of data protection is not an abstract thing. It is there, it's protected, and because of the new EU regulation that will emerge next year in 2018 in May, if you process data without the good reason, without the consent or other basis for doing that, you may be fined for a huge amount of money, which goes to up to 20 million euros. That's a lot. I'm not saying that a small developer will be fined in that amount, but even if you're fined with 100,000 euros, it's still a lot. You can do quite other work with that money, not paying it to the regulator. There are other aspects of it's called GDPR, the regulation I was speaking to. I only point out a few. Territorial scope, it basically says that it doesn't matter if you're a US company, if you process data of European citizens, this regulation applies also to you. The consent of parents to process data of kids. So basically, if this is a kid of 13 years old or younger, you need the consent of the parent to process data. And in terms of video games, online video games, there is no answer right now what is the technical solution to acquire such consent from the parent? Because ticking the box won't work, because you will need to establish, to prove that the parent themselves, the parents, they were actually giving the consent. So how to do it? It's still a question mark next to it, but there is a lot of work to do in terms of the administrative fines and the accountability. That the thing that it's not a list of obligation and requirements that you just need to follow and you'll be on a safe side. No, there are no more the traditional obligation and requirements. You just need to make sure that the privacy, that the data protection of your users is well protected, and you need to be able to prove it any time that the regulator or the physical person asks you to. This is very hard thing, not only it doesn't affect only video game developers, but also publishers, the marketing, not the marketing, the platforms like Steam, for example, GOG, and any others that sell the games, it's all tied to each other. In terms of an example, for example, I'm making a MOBA game, and I decide, so the core game is the code and graphics to simplify things, and of course I need to implement the matchmaking system, but to make it, for example, I decided to do the matchmaking systems in two ways, by region and by skill, and to cut my costs. I'm not gonna make through the real hardware servers, but I'm gonna put everything in the cloud. So I'm just gonna pay the subscription to Microsoft or Google to store my data in the cloud. But the problem is not the problem, and to simplify the access for every players. So the question is, if there is any privacy issue with that. Yes, there is. There is a big issue. These are not all the issues that are involved with creation of MOBA under such a scenario, but matchmaking system goes to data profiling, to processing data of users, and like I already said when I was speaking about big data and data profiling, you need to establish mechanisms how data of your users is protected. For example, because under the new regulation, every person has a right to not to be subject to automatic matchmaking system, profiling system. So in terms of matchmaking, for instance, imagine the whole game is based on matchmaking, like any MOBA game, but also any FPS game when you play online. And then you receive a letter from the user, and it says that, okay, I want to play the game, but I don't agree to be subject to automatic profiling system, and I want a human factor included in it. It's impossible right now to. It's just impossible to put it in into the game. I can't imagine a person deciding who's gonna play with who over the game. And then again, the personal data of kids. There are so many players that are below the age of 13 years old. So how to receive the consent from the parent, that's a question mark. And but then again, it needs to be addressed. And servers in cloud. What's the cloud? It's basically many hardware servers connected each other, usually separated by seas, by countries. And very often, even the providers of the server, the cloud services, they are not entirely sure where the data is. So let's say I put your data into the cloud, and a piece of your data is in Ireland, another piece of your data is in India, and another piece of data is in the United States. So now we have 3 countries and 1 piece of information. How to inform your users where the data is, how to secure their privacy. India, for example, is very efficient for keeping data because they have very cost-effective cloud services, but there's very huge problem with protection of the data. So just keep that in mind. State aid funding. I'm just going to go very quick through that. There is an opening for gaming. It's a state aid funding when project for video game development may receive up to almost 20 million zlotys for the creation of game, depending on how the costs are structured. And it's open to everybody. It doesn't have to be a Polish company. All you need to do is to have some establishment in Poland. You can also go into the consortia with other developers, and not only video game developers, any other companies and legal entities. And the submission is open until July 6th. It's right now it's the best, the smartest way to receive public funding. It will not be renewed, the program, until next year, but it's not confirmed yet. And it's 100 million zlotys to give away to video game developers. So at least consider it. It's all the documents, all the information are on the website of the National Center for Research and Development. it's older. It's in Polish, unfortunately, so I'm not sure about the translation of documents, but at least consider that. It takes some effort to prepare the application. It's very formalized, but it's worth that effort. Infringement of IP rights. I just want to point out that you do not want to infringe the IP rights of others just for these three reasons. Damages for infringements are very high. In Poland, right now, the damages for infringement of IP rights of others, of copyrights, is it's basically the double of what you would pay under the market circumstances at the time when you started using that IPR. So if the judge would establish that, okay, if you go and ask for the agreement with the IP owner, and he would say, I will give you, I will license you that IPR to you for 5 years for 1 million zloty. If you infringe that right, you would have to pay 2 million zlotys. And it goes straight from the statute itself. And it also, it's very often that you just receive an order to stop distribution of the game, and then you're cooked. If you created a game, it's already packed in boxes, and it's about to be shipped worldwide, then you receive that order, and no box can leave the country. You cannot do anything with the game. For, I don't know, before that, the first trial, we probably 5 to 6 months, and you will have to postpone the premiere of the game, I don't know, for a year or two. The game is dead already. Yeah, or if the owner of the IP approaches you and says, okay, I can pursue the lawsuit in the court, but I'm also willing to go into agreement with you, but that agreement would not be favorable for you. You will be able to probably use the IP rights, but under very, very severe conditions, and you may not be able to monetize that game anymore. This is a case study of No Doubt versus Activision. Basically, they used the avatar of Gwen Stefani, but you were able to play other songs while the avatar of Gwen Stefani was pictured. And yeah, no doubt they were not very happy that when somebody could play Honky Tonk Women and portraying Gwen Stefani at the same time. So the case was settled, but this is just the example that even though you have all the rights to use the appearance of the real person in the game, you still may go into the trouble. The last one is Tetris versus Minions, the very famous case. Tetris, of course, was first. It's an example of cloning of games. The court itself was not sure which one is Tetris when they were considering the case. Tetris is the one to the right. Yeah, it's an obvious cloning. It was obvious for court. It's not always that simple with cloning games, but you need to be aware that when you decide to use the success of other game and make a similar game, you may need some form of an analysis of what you can do with the game in terms of not infringing copyrights. Oh yeah, these are just the 5 things to remember before you guys go. Get a license before you start developing a game, if you need one, unless you create your own IP, of course. Try to sign the best possible contract with the publisher or other entity that would put money into developing of your game. Never assume that the other party that approached you has the best intentions for you. Sometimes they don't. And think about securing your trademarks, and don't forget about getting a license or consent to use trademarks of others. Or remember the Microsoft and Mythica case. Keep in mind data protection if your game is based on processing of data, especially in terms of mobile market, and do not infringe IP rights of others. Thank you.
Okay, we still have some time for questions. Any questions from the audience?
Hello, you have mentioned the example of license for using a car, BMW, and in previous versions of GTA there were cars that were very similar to real cars, but without the actual name. Where's the line between the similar but not that car and really it's that car?
That's the work for lawyers, unfortunately. No, well, sometimes it's obvious that the car it's based on a real model of car that drives on the street, and there is a very thin line between what it's called. I forgot the word. The idea for using something and the infringement of the real work in that example, and there is no straightforward simple answer to that. Every case needs to be analyzed on case by case scenario. So if you show me an example of a car which is similar to the car that drives on the street, I could try and debate with you whether there is a risk for infringement or not, but there is no like a bottom line, like a guide or on what to do and what to don't do not, unfortunately.
Is there a type of list or website of trademarked names for open to check out?
Yeah, every country has its own database, and it's held by the patent office in every country. In Poland, it's the Polish Patent Office. In US, it's USPTO. It's United States Patent Office, and it's a public available website. You can go there. You can type the name of the trademark. You can type the name of the owner. You can try some other fields of the keywords that you would like to put. For example, in which class the trademark is registered, or for what goods, in which class of classification. It goes to more and more detail, but it's for free. It's available to everybody. But yeah, so it's always use the public databases which are available to everybody. In each country that you would like to use the trademark. In Europe, it's even if it's gonna be just one country for some reason, also go to the website of EPTA, which is the European Patent Office, because in Europe we have not only the national trademarks, we also have the European trademarks. So even if I'm staying in Poland, I can register my trademark for the whole European Union, for instance. But it's all for free. It needs a bit time to feel comfortable on how the work side works, but it's doable to everybody on the basic level, at least.
Any other questions? No questions, I guess. Okay, so thank you very much again.
Thank you.